Hello, and glad to have you on New York's Asset Protection Roundtable, a three pillars of protection program with Ted Alatsis, attorney and counselor at law at the Alatsis Law Firm there in Brooklyn, New York. Got a good show for today. We're going to open up the mailbag once again and answer your questions. We'll also have a little legalese of the day. But Ted, first, how are you?
Doing well, Ben, and spring is sprung, and it's a beautiful day out there. So enjoying the weather.
I know you and the wife enjoy traveling quite a bit. Do you have any big trips planned?
Well, we're hoping to head out to Greece this summer for a couple of weeks and see if we can get that on the calendar. We're trying our best.
Was that a yearly trip?
Uh, Probably every couple of years. You know, it's a big trip and a big amount of time on a plane, and I'm not a big fan of being on a plane for a long amount of time. But we try to get out there a few years, every few years if we can.
I love that. What's the one thing you look forward to when you make the trip over?
Well, I still have family there, so seeing my family, but the beaches. I mean, the beaches are just phenomenal. So yeah, we do enjoy those.
Tremendous. Well, hope you're able to make that trip and enjoy your long flight. I'm sure it'll be worth it once you get there. But we got a good show for you today. Again, I'll remind you, if you have questions for Ted that you want to send in to us or just ask him directly, you can always log on alatsaslawfirm.com or give him a call at 718-233-2903. As we like to do, we have a legalese of the day, a term that you might hear during the estate planning process or might have heard mentioned at some point, but aren't quite sure what it means. How about this one, Ted? Pet trust. What is that?
All right. So a lot of people, in this day and age, and this has become much more popular in the last few years, that at least in my practice, have pets, right? And pets are family, right? So a dog or a cat, or multiple dogs or cats, and other pets that essentially have become part of the family. And when a loved one passes, or when they pass, they want to make sure that the pets are taken care of. And so setting up a pet trust is one way of making sure that there's money and direction as to what's to happen with the pet, to keep the pet alive, or maybe to ensure that the pet goes to an appropriate shelter, so that the costs of maintaining that pet are taken care of, right? So setting up a trust within an estate, or whether it's in your own trust, or whether it's in your will, is one way to go about making sure that there's funds provided and set aside for that purpose.
Is this a common thing? I don't know that I've heard about this. Do you have many pet trusts that you're setting up?
I've done a few over the years, and it's become much more common in the last 5 years than I've ever seen. Certainly, but yeah, it does happen, frequently. So I've seen it, we've done it, and yeah, it does happen a lot more than you would think.
Okay, very good. So pet trust, your legalese of the day. All right, let's dive into the mailbag now and got a few questions I want to answer here on the show today. We'll take this first one from Ava. Here's the situation, Ted. She says, my ex-husband and I have joint custody of our daughter. He is horrible with money. I know if I pass away, my daughter will end up staying with him as the sole guardian. However, I do not want him to be in control of the money I leave her. Is there any way to keep his hands off the money?
Yes, absolutely. So, this is where planning your estate um, is an important facet of what you do, because certainly, given the circumstance, you don't want to necessarily have the money in his hands. So you can certainly set up a trust within either your will or maybe your living trust, that it sets aside money, and have a trustee who's appointed, who would be other than your ex-husband. And the purpose of the trust would be to maintain that money for your daughter, Ava, so that this way the financial needs are met, and there's someone with financial responsibility who's not your ex-husband, so that the money will be there for the child as long as possible.
Yeah, I'm sure this is a probably, I won't say common, but I'm guessing this is a situation that happens pretty frequently.
Yeah, it does, and it's not even necessarily in the ex-spouse scenario, but sometimes when a person named, or a couple name, someone to be guardian of their children, they may not necessarily you know uh, have the same financial wherewithal that the parents do, and so they could appoint a trustee to manage the money, while they have another person who's who's taking care of the child or children. So it's not uncommon. It's also a good way to kind of have a check and balance approach, so that the child's emotional needs and health needs are being met, while at the same time their financial needs are being met, and the two can be aligned.
All right. Thanks for that question, Ava. We appreciate that. Next one comes from Elijah. It's a good question about divvying up within your family. He says, after my wife died, I couldn't take care of the house by myself. I sold it and moved in with my son. He remodeled his house and takes care of me, and he doesn't charge me rent. So I want to leave him extra money when I pass away, but I don't want to upset the other children. So what's the best way to go about this?
Great question, Elijah. So we run into a scenario like this very often. Okay, and part of that is because it costs so much to grow old in the United States. And so rather than end up in a scenario where you're at a nursing home or something like that, to have a child help assist in the care is a beneficial way of going about doing that. And so we do run into a scenario like this often. There are a lot of different things we can do here that would make some sense, but the most important thing is communicating your intentions with your family, right? Let them know ahead of time that that's what you're planning on doing and why. The communication is probably the most important part of this, and then dealing with how you're going to divvy things up later. That's more technical. That's more a semantic type of thing. But the communication is the most important part. Have that communication, have that conversation with the rest of the family. Let them know that your intentions are to leave a little bit more to your son, and then the way it can be dealt with is with a very specific bequest, and a statement that kind of says the reason why you're doing that, whether it's in your trust or in your will. That probably be the most important thing, is the communication.
And that's one of the beauties about working with an estate planning attorney, right, Ted, is that you don't have just kind of a cookie cutter approach to your will. And it's the ability to sit down and kind of lay all this out and make sure you have the exact plan that you want that fits not only what your goals are, but also takes care of your family as well.
Yeah, it's exactly right. It's that's the difference between documents and planning, right? Because at the end of the day, documents, anybody can do documents. That's easy enough. You can go online, you can go on our website and do documents yourself if you really just want documents. It's the planning part. That's where the real lawyering is done, and that's where the real consultation and the participation that takes place, where that really makes a difference.
All right, I have one more question here on the podcast that came in from Mike, who says, I want to give everything to my son when I die. I trust him already. Why can't I just give him my house and my investments while I'm alive? Is that a bad idea?
So, Mike, this would be one of those perfect things for you to, listen in on our workshop, How to Protect Your Stuff in 3 Easy Steps. Because we talk about, scenarios just like this, right? There are, real downsides to just giving everything you have to someone while you're alive. First, you lose all control. Once you've done that, there's absolutely no way to get it back. So if the relationship between you and your son, falls apart, now all of a sudden you're broke and you're not gonna be able to get any of it back. Number one. Number two, when you give things to someone and they now own it, they possess it, anything they can save, spend, or give away without any kind of restriction can be taken away from them by their predators and creditors. So if you have, so if your son has $200,000 American Express bill that hasn't been paid, well, guess what? You've just given American Express your money, and that might not be the scenario you wanted, or the result you wanted. So there are ways around that, and doing a trust and putting the assets in a trust, for example. That's one way to protect that. And then there are other ways as well, but certainly, just giving it away is ultimately probably a bad idea.
All right, great question, Mike. And again, if you have any specific guidance you're looking for or want to begin your estate planning process, you can always log on alatsaslawfirm.com. Ted is happy to help you or anyone in your life build their estate plan and make sure that you are taking care of your family or those that are close to you or the causes that are close to you when you pass, and make sure everything goes where you want it to. And again, that's the difference between planning and documents, as we pointed out there just a few moments ago. So if you have questions for Ted, you can also call in. 718-233-2903 is the number, but we always appreciate hearing from you on the podcast, and we'll answer some more questions coming up in a couple episodes, so send them in to us. Ted, as always, pleasure catching up with you, and we'll talk again soon.
Absolutely. Have a great one, Ben. Thank you.
Thank you for listening to New York's Asset Protection Roundtable, a 3 Pillars of Protection program. For Ted Alatsis over at the Alatsis Law Firm in Brooklyn, New York, I am Ben George. Have a good week.